This is part 4 as far as our lecture series on the Indian Penal Code of 1860 is concerned. And then we have started understanding the importance of the chapter, introduction to the chapter, so that it becomes very easy for us to work out the details. And then in the last lecture, if you have not forgotten, we have started discussing the chapter, importance of chapter, introduction to the chapter, right from section 53 up to section 75 of the Indian Penal Code, which is on punishment. Now, when we shall be dealing with this chapter, we shall be definitely dealing with different kinds of punishment, and which are the various kinds of punishment with which we shall be dealing. The maximum punishment that can be inflicted by the court of law is death penalty. The court has also got power to ask a person to undergo life imprisonment. The court has also got power to ask a person to undergo imprisonment which may be rigorous or simple. Court can ask a person to pay a fine. Court can impose a fine, no doubt about it. There is a provision, barring few exceptions, let me tell you, to pass an order regarding forfeiture of the property. And the last type of punishment with which we shall be dealing is solitary confinement, for which we shall be dealing with two sections, namely section 73 and section 74, as far as this chapter of the Indian Penal Code is concerned. We will work out all the details, yes. But this is also the time for me to remind you and tell you that, dear students, pronouncement of the sentence is by the judge. But execution is not by the judge, execution is by the government. And as far as execution, suspension, remission and commutation of sentences are concerned, if time permits, do refer to right from section 413 up to section 435 of the Criminal Procedure Code to have clarity regarding understanding of the punishments. Yes, this should be the approach. And then if you follow this approach, then for the purpose of understanding different kinds of punishment, no. But then when we will try to understand these punishments in detail, that is one aspect with which we shall be dealing as far as this chapter is concerned. And then if somebody commits offense of murder and if he is punished by the court of law, what is the purpose that is served? And in order to understand this, along with this simultaneously, we shall be dealing with different theories of punishment, kinds of punishment. Different theories of punishment. And when we shall be dealing with theories of punishment, what is the purpose that is served by convicting a person who has done a wrong or who has done an act which amounts to an offense? We shall be dealing with what? We shall be dealing with 1. Deterrent theory of punishment, 2. Retributive theory of punishment, 3. Preventive theory of punishment, and last but not the least, what is meant by reformative theory of punishment, with which we shall be dealing during course of our lectures. When we shall deal with death penalty, that is the maximum punishment which is inflicted by the court of law, and you find out the sections where the death is the maximum punishment that can be inflicted by the court of law, and you will find out there are around about 7 sections in the Indian Penal Code where you come across the maximum punishment is the death penalty. But is it that the court is bound by law to pass a sentence when the offense is punishable with death sentence? No. Mind well one thing forever, when we shall deal with this chapter, I will make this very clear that when the maximum punishment is laid down by the section, minimum sentence is entirely at the discretion of the court of law. And what is this minimum sentence is for the court to decide by taking into consideration what? Taking into consideration the age of the offender, his family background, his educational background, his social background, his cultural background, what compelled him to do an act which amounts to, all these factors are taken into consideration by the court of law. And as far as death penalty is concerned, Though I told you that, well, we won't refer to the provisions as far as the case law is concerned because it may be difficult for you, but here I will have to draw your attention to Bachchan Singh's case, which was decided by the Supreme Court in the year 1980, where Supreme Court has laid down a principle that death sentence, even though maximum punishment can be death, it should be inflicted by the court of law in only rarest of rare cases. And what is this rarest of rare cases is made very clear by the Supreme Court. For this you will have to have reference to that. Yes, because that has laid down a law as far as Article 141 of the Constitution of India is concerned. Yes, life imprisonment. What is the meaning of it? Don't equate with 14 years. Don't equate it with 20 years. No, certainly not. Life imprisonment does mean person should be behind the bars for the entire period of his life. But then, for the purpose of understanding this, we will have reference to section 55 and section 57 as far as Indian Penal Code is concerned, to be read with what? To be read with section 433 and section 433A of the Criminal Procedure Code of 1873 is concerned, with which we shall be dealing when we will work out details regarding the chapter. So this is introduction as far as this chapter is concerned, right from section 53 up to section 75 of the chapter 3 of the Indian Penal Code, dealing with what? This chapter of the Indian Penal Code is on punishments. With this now, if you refer to right from section 76 up to section 106 of the Indian Penal Code, heading of the chapter is General Exceptions. Now I shall be dealing with this chapter as soon as I finish with most of the part of the Indian Penal Code as far as the offences are concerned. You can't understand this chapter unless you know at least some of the offences by name. What is wrongful confinement? What is assault? What is murder? What is rape? What is kidnapping? What is abduction? Then only it is possible for you to understand, otherwise not. General exceptions right from section 76 up to 106 of the Indian Penal Code. Now what is the importance of this chapter? Every section, barring only one section, and that is 94 section, starts with the wording nothing is. For example, you read section 80, which says nothing is an offence which is done by accident or misfortune without any criminal intention or knowledge in doing of a lawful act in lawful manner by lawful means with proper care and caution. Are you supposed to remember section in this manner? Certainly not. You must, be in a position to read the section, analyze the section, carry out the section and try to remember the ingredients of the section accordingly. Section 96 says nothing is an offence which is done in the exercise of the right of private defence. Yes, whatever is done as far as exercise, when you exercise the right of private defence, we shall be dealing right from section 96 up to 106 of the Indian Penal Code. And whatever you have done, whatever nature of the force that is used which has resulted into bodily pain to an individual, that will not amount to an offence because of section 96. It says that is not at all an offence. If the act is done by child, read section 82, which says nothing is an offence which is done by child under 7 years of age. Whereas if you refer to section 83 of the Indian Penal Code, which says nothing is an offence which is done by child who is above 7 years of age under 12 years of age, who has not attained sufficient maturity of understanding to judge the nature and the consequences of his conduct on that particular occasion. So what do you mean by act of a child as a defence? Why? With which we shall be dealing, because yet I have not told you the concept of mens rea, guilty mind. Unless an act is done with a particular criminal intention that is not made punishable by the provisions of the Indian Penal Code, this is based on the maxim actus non facit reum nisi mens rea, with which we shall be dealing. What is the meaning of this maxim? The meaning of this maxim is that the intent and the act must both concur to constitute an offence. Mere act is not made punishable. Mere intention is not made punishable. Simple definition of an offence with which we shall be dealing during course of our lecture is offence is equal to mens rea, namely guilty mind, plus actus reus. And what is actus reus? It's such result of the human conduct that law seeks to prevent, with which we shall be dealing. There are many more provisions with which we shall be dealing, but let me first of all finish with the introduction. Introduction as far as chapters are concerned, and come back to this. Because when we talk about mens rea, we will come across, you will immediately point out, raise a question, sir, we have never come across this term mens rea anywhere by reading any one of the sections of the Indian Penal Code. Yes, I do agree. But does it mean Indian Penal Code has dispensed with mens rea? Certainly not. If you read a section, state of the mind of an individual with which a particular act is required to be done is included as far as definition of an offence is concerned. Dishonestly is mens rea. Fraudulently is mens rea. Voluntarily is mens rea. When we will read section 299 of the Indian Penal Code, which defines culpable homicide, you will come to know what is culpable homicide. Section 299 says, whoever causes death by doing an act with the intention of causing death, or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commits the offence of culpable homicide. Intention is mens rea. Knowledge is mens rea. So these are the various, with which we shall be dealing. So when we shall be dealing with general exceptions, we'll try to understand what do you mean by, if the act is done by a person who was a person of unsound mind, as far as insanity as a defense is concerned, with which we shall be dealing as far as section 84 is concerned. In other words, whatever may be the consequences of the act which is done on the part of an individual, if it falls under any one of the exceptions, and hence legislation, general exceptions are general defenses, and general exceptions are exception to every section which defines an act which amounts to an offense. And why the legislature have thought to have this chapter right in the beginning? In order to avoid repetition. Whenever you read any section as per which offense is defined, you have to read that section subject to exceptions right from section 76 up to 106 of the Indian Penal Code. And then this is the importance of the chapter. And in order to understand the importance of the chapter, let me make one thing very clear to you, that as a student learning criminal law, if at all you come across a situation where somebody is accused of an offense of murder, now we don't know whether he has committed the offense of murder or not, but he was arrested by the police. They started with the investigation, they collected evidence, everything was taken before the court of law. This part of the Criminal Procedure Code I may introduce you. That is made very clear as far as the Criminal Procedure Code is concerned. But then, this is the time where I will have general introduction, what is done. So now this person, when he is taken before the court of law, accused person we call him, accused person becomes an offender only when his guilt is proved beyond reasonable doubt in a court of law, otherwise not. He is suspected, he is accused of an offense, he is charged that you have committed the offense of murder. What are the defenses that are available to him in a court of law? Now he might have committed offense or he might not have committed an offense. The first defense that he can raise, because now as you will have an advocate on behalf of the prosecution, he will also have an advocate, and he has got right to consult and to be defended by an advocate of his own choice. That is a provision as far as the constitutional law is concerned, and to be read with the provisions of the Criminal Procedure Code with which we shall be dealing. But when he is taken before the court of law, let me tell you one thing, he is presumed to be an innocent person. And How long? Till his guilt is proved beyond reasonable doubt in a court of law. So what is required to be done? This person who is taken before the court of law in order to undergo trial for the offense of murder will, first of all, he can raise a defense, and the defense is what is known as defense of total denial. And what he will say? I do not know anything. I do not know anything. Don't ask me anything. I don't want to tell anything. I am not aware regarding anything. This is the defense of total denial, where he may not lead the evidence. The second defense that he can raise is the defense of alibi, where he can try to prove in a court of law that as per your story, namely the story of the prosecution, the offense has taken place at a particular place, and on the date of that commission, alleged commission of an offense, I was at an entirely different place, for which he can lead the evidence, no doubt about it. And then if he is successful to prove that he was not at the place where the offense has taken place, question of his liability doesn't arise. And this has got reference to what? This has got reference to section 8 of the Indian Evidence Act. Generally, when we talk about motive, when we talk about conduct, we talk about preparation. Yes, to be read with, that is not relevant, but becomes relevant as far as section 8 is concerned, and this alibi has got reference to section 11 of the Indian Evidence Act. Generally that is irrelevant, but that becomes irrelevant from the point of view of coming to the conclusion to find out guilt of an accused person. So this is we will work out some of the details, no doubt about it, but all details cannot be worked out, because this is a lecture with which we are dealing as far as Indian Penal Code of 1860 is concerned, and hence don't have confusion when I refer to some of the provisions as far as the Criminal Procedure Code is concerned, some of the provisions as far as Indian Evidence Act is concerned. Simultaneously you shall be used to it to understand the same. Yes, it is only because of the practice, it is because of the method, it is because of the aptitude, it is because of the approach that it will be possible for you to understand mind well. And if this is the approach, well, you can master everything which you want to do as far as understanding of the law is concerned, with which we will continue, no doubt about it. So this is. Now lastly, the third defense that can be raised on the part of an accused person, he can admit, yes, he will say, yes, I have killed somebody, I have killed somebody. My act has resulted into death of somebody, no doubt about it. But I am not liable, because my case falls under any one of the exceptions, right from section 76 up to 106 of the Indian Penal Code. And if your case falls under any one of the exceptions, as far as general exceptions are concerned, and this has got reference to what? Do have reference to right from section 101 up to 114A of the Indian Evidence Act is concerned. And then if you read this chapter, and what is the heading of the chapter? Right from section 101 up to section 114A of the Indian Evidence Act of 1872, burden of proof. And then if you have got reference to section 105, it says, if you want to prove that your case falls under any one of the exceptions right from section 76 up to 106 of the Indian Penal Code, the burden of proof is on the accused person. Guilt of the accused person is required to be proved beyond reasonable doubt by the prosecution. It is not for him to prove that he is an innocent person. No, certainly not. It is for the prosecution to prove, and the guilt is required to be proved beyond reasonable doubt. And what is it beyond reasonable doubt, with which we shall be dealing during course of time, no doubt about it. But otherwise, this should be the approach. So these are general exceptions with which we shall be dealing right from section 76 up to section 106 of the Indian Penal Code. Now, if possible, yes, you do read, no doubt about it. But for the purpose of understanding general exceptions, as if you go through section 97 of the Indian Penal Code, which says, every person has got rights subject to the restrictions contained in section 99 to defend his body and the body of any other person against any offense affecting human body. Now, what are the offenses affecting human body? And in order to know the offenses affecting the human body, you must know offenses right from section 299 up to section 377 of the Indian Penal Code. Then only you can understand the right of private defense. Yes, when we will deal with right of private defense, we will classify, we will club the sections together and try to understand this right in different contexts. In the sense, what is this right? When the right commences, how long the right continues, when the right ends, when the right extends to the causing of death, and what are the restrictions or limitations with respect to this right, with which we shall be dealing, no doubt about it. But then to understand this right, or if you read, for example, section 97, it says, every person has right subject to the restrictions contained in section 99 to defend the property, whether movable or immovable, of himself or any other person against any act which is an offence falling under the definition of theft, robbery, mischief or criminal trespass, or which is an attempt to commit theft, robbery, mischief and criminal trespass. So you must know the offences, and then you will start, as I told you in the past, if you remember, we have to start right from section 378 and go up to section 462 for the purpose of knowing offences against property or relating to property with which we shall be dealing. And hence the reason why I have told you that to understand general exceptions, you must have understanding regarding various offences with which we shall be dealing during course of time. So this is regarding general exception with which we shall be dealing right from section 76 up to section 106 of the Indian Penal Code, where we will classify the general exceptions. For example, when we will deal with a topic as far as general exceptions are concerned, incapacity to commit an offence. Who is incapable? Who is not capable of committing an act which amounts to an offence? We will deal with intoxication as a defense, for which we will refer to section 85 and 86. We will deal with insanity as a defense, where we refer to section 84, act of a child as a defense. And then this is the part with which we will continue. What do you mean by mistake of fact as a defense, for which you will refer to section 76 and section 79. When we want to know act which is done by judge or which is done by the direction of the judge, how it is defense, for which we will refer to section 77 and section 78 of the Indian Penal Code. Yes, that we will do. What do you mean by, as I told you, accident as a defense? We will deal with section 80 of the Indian Penal Code. And then we will proceed accordingly for the purpose of understanding the same. But this is, try to understand what is the importance of this chapter and why we are not going to deal with this chapter right in the beginning. Though the legislature has got this chapter, before defining any act which amounts to an offence, legislature thought of having this chapter for this reason. That was the intention of the legislature, that let us first of all avoid repetition. Otherwise it would have been, if this chapter, there would not have been this chapter in the Indian Penal Code, it would have been must for the legislature to repeat all general exceptions right from section 76 up to 106 of the Indian Penal Code after every section of the Indian Penal Code. That is, naturally, repetition is avoided by the legislature by having the general exceptions right from section 76 up to 106, with which we shall be dealing. This is chapter general exception right from section 76 up to section 106, with which we shall be dealing during course of time. With which now, if we come to the next chapter and start reading right from section 107 up to 120 of the Criminal Procedure Code, of the Indian Penal Code, namely chapter 5 of the Indian Penal Code is on of abatement. Now let me tell you right in the beginning, abatement is not an offence. Abatement of an offence is an offence. And hence, once we start, it's not only one who has done an act which amounts to an offence is punishable by the law. No, one who has instigated him, one who has conspired, and on whose part there is what is known as intention laid, is also made punishable. So that is done. This is the chapter with which we shall be dealing right from section 107 up to 120. Now the first time that I want to draw your attention in order to understand the importance of abatement, is it necessary for you to read all the sections? And hence, read the heading of this section, and once you start reading heading of the section, you understand. And what you should read, that I have told you in the first lecture itself, always concentrate on that section which does not deal with punishment. Yes, punishment, I mean, you read and you understand punishment. There is nothing for you to nothing for you to try to understand, because it's just what is the quantum of the punishment that can be inflicted by the court of law. You read the section and you understand. But what is abatement and rest of the details, with which, as far as this chapter is concerned, we will continue our discussion as far as our next lecture is concerned.